to Milena. Thank you.
Grazie, Deborah, for the introduction at the beginning. And thanks for inviting me. When I got the invitation, I was really happy because I got to participate in another discussion on criminal disenfranchisement. And that's something I've worked for a long time on, but I haven't been working on intensively in the last few years. So I was also very happy when Howard League Scotland invited me to kind of share my views on the proposals that were only kind of being considered before they actually reached the Parliament. And I worked a little bit with them and we tried to develop a kind of a proposal that would expand the franchise as much as possible, but at the same time be realistic in the sense that we were aware that none of the parties would actually support a very large extension of voting rights to anyone almost, or the majority of the population, of the criminal population, so to say. So what we proposed in the end is very much in line with what the Greens thought would be appropriate, and that's to extend the franchise to all people who were serving sentences of 4 years then less. But as Luke already explained, that didn't go through, and what happened was a significantly lesser expansion of voting rights. So to just kind of continue where Luke left off, when the bill was passed, the already mentioned Michael Russell, who is the Cabinet Secretary for the Constitution, Europe and External Affairs, said, and I quote, "This legislation also ensures that Scotland complies with the European Convention on Human Rights when it comes to the issue of prisoner voting by making provision for the franchise to be extended to those serving a custodial sentence of 12 months or less." But as I'll try to kind of show in this brief presentation, this isn't actually the case. And with the new restrictions, Scotland definitely does not comply with the ECHR. So to me, it's surprising that this bill went through because of a number of previous judgments in which these kinds of policies were openly struck down by the ECHR. So what I'll try to do in this presentation is just kind of give you an overview of where things stand right now, and just to kind of discuss a little bit as to what can be inferred from the ECHR's judgments in terms of what would constitute an appropriate disenfranchisement or enfranchisement mechanism. So yes, the ECHR does say in their Hearst judgment that the right to vote is a right and is not a privilege, but at the same time it recognizes that the right to participate in elections is not absolute. So it's not right to life, it's not absolute, it's limited. And the states actually enjoy a margin of appreciation when deciding about the limitations that they want to impose. And the ECHR also recognizes in various judgments that these limitations might be quite different and still be in line with the convention, so countries can impose them without being in breach of the ECHR. So what the court is trying to say is that it does not require uniformity, so countries can have different solutions and it would still be acceptable. So this is very important. And the second important thing, and there are three important things, the second one is that from the analysis of the judgments itself, and that's something that I kind of explore a little bit more in the book, it emanates that criminal disenfranchisement is understood as a form of punishment. So it's properly understood as a criminal sanction. And this is really important because it does then set out the parameters for determining whether this sanction is justifiable. So if the court says this is a form of criminal punishment, then we already have some kind of principles that we need to think about when we think about whether this is justified. Things such as the severity of sanction must relate to the severity of crime and these and similar kinds of things. So what I would argue, and that's the third thing I want to just address briefly, is that one of the key principles that has informed the judgments of the court is the principle of proportionality. And you can kind of see principle of proportionality figure very strongly in all the decisions. So in Hearst, the court has stated that there must be, and I quote, a discernible and sufficient link between the sanction and the conduct and circumstances of the individuals concerned. So on the one hand, we have the sanction, on the other one is the conduct and the circumstances. And I think this is a very strong expression of this idea that we need to assess whether disenfranchisement is justified. And I think this can mean one of the two things. So in terms of what concrete rules countries may adopt. So on the one hand, we can have a situation where the law doesn't stipulate in advance the situations in which criminal disenfranchisement may occur, but those who impose criminal punishment, so judges in general, would have to engage with the circumstances of the case and then figure out based on that whether criminal disenfranchisement is warranted. So that's one kind of option, one method. The other method, which, as Luke said, a number of countries actually employ, is a situation where the law specifies in advance the kinds of crimes or the gravity of crimes, which is usually inferred through the sanction that was imposed, which warrant criminal disenfranchisement. So already in the law, you have situations which might lead to disenfranchisement, and these situations are either defined through the kinds of crimes or the gravity of crimes. In that second situation, again, there are two sub-situations. In the second situation, criminal disenfranchisement would then be either automatically imposed if someone has perpetrated a particular crime, such as, for instance, terrorism. So you have automatic loss of electoral rights, or it could be also another situation where this could in principle be imposed, but then the judge would have to decide whether in the given case it's appropriate. So it's an even more complicated system. Regardless of these various situations, it seems to be that all of these solutions would be acceptable to the court because they would all, in one way or another, take into account what has been perpetrated and whether criminal disenfranchisement would be justified. So from the judgments, because they've looked at various different, and I'll talk about judgments in a second, because they've looked at various different situations, different countries that employ different rules, it seems to be that the court is very open to different kinds of provisions. So it doesn't require uniformity, and I've just kind of explained a little bit what these kinds of systems, what the norms could potentially look like. So I'll just give you now a very brief overview of what is definitely not acceptable. So the kinds of situations that the court has previously found to be in breach of the European Convention of Human Rights. And that's something that I'm actually a little bit surprised about, that whoever came up with the final definition of the law didn't really engage with the judgments of the ECHR, because if you look at the judgment, it becomes fairly obvious the kinds of policies that would not be acceptable to the court. Okay, so there are three things that we can definitely say are not acceptable and would not cross the threshold that the court has set. First of all, disenfranchisement of anyone convicted of any criminal offense perpetrated with intent. And this is the policy, the policy that was discussed is the policy of Turkey, two cases, Scheuler and Vural. So Turkey had a policy whereby they would disenfranchise anyone who had perpetrated any criminal offense, but just if it was perpetrated with intent. So that was kind of the only qualification. The court found that this policy is indiscriminate, it's automatic, and it doesn't actually look into the link between the offense and disenfranchisement. Secondly, the policy which disenfranchised all convicted prisoners, and you will know this policy obviously it's most known probably because it was the policy that was discussed in Hearst, but it existed in other countries. So I'm pretty sure, so the rest of the countries that were discussed were Russia and Bulgaria, so cases Antrukov and Gladkov, Kulinsky and Sabev and Ramishvili. In all these cases, the court found, again, as in the case of Hearst, that disenfranchisement is too blanket, it's too wide in scope, and doesn't take into account the relationship between crime and punishment. And the last one, which obviously is another case that's quite known. It was the policy of Austria. The case in question is Frodel. And in this case, the court found that disenfranchisement of prisoners who are sentenced to at least 1 year of imprisonment for an intentional crime is also not acceptable. So that's something similar to what Scotland has done now, but it's even more limited, right? Because it says prisoners sentenced to at least 1 year of imprisonment for an intentional crime. And this was not accepted by the court. And in this case, I think this is the most important case for our discussion, because even though Austrian policy was less restrictive than the UK's, it was still considered too automatic because in this given case, there was no participation of the judge, no acknowledgement of the circumstances, and no link between the offense and punishment. Okay, so that's what would definitely not be acceptable. And I'll just kind of finish with some of my own considerations and thoughts on what could potentially be acceptable. And then just close with a couple of remarks. So the only case that's very indicative and that's very important for us is the Italian case of Scopola. And Italy's policy was actually the only one that was questioned and upheld by the court. And Italian policy is fairly complex, but I think it offers a really good, kind of a thing to consider when we think about what might be an acceptable regime. So in Italian case, what was discussed was a disenfranchisement, which was only possible for prisoners who were sentenced to at least 3 years of imprisonment, so significantly higher level, or those convicted of specific offenses, such as those against the state or the judicial system. The Italian legislation actually then has two parallel systems that run kind of independently of each other. And the court in this case held that it may be appropriate to impose criminal disenfranchisement merely based on the fact that a particular sanction has been imposed. So this is very significant. The court actually said, in this case, for us, it's acceptable to decide to impose disenfranchisement just on the basis of the sentence. And before that, we didn't really know whether this kind of policy would be acceptable. But you see that the threshold for the court, well, it might be even less than 3 years, but 3 years is definitely acceptable for the court. So the court actually here said, we don't require that criminal disenfranchisement is linked to a particular crime. It can be imposed, even if it's linked to a particular sanction. But I think, and this is my interpretation, that this was only warranted because criminal disenfranchisement in Italy is part of a wider ban to public office. And the ban of the public office the duration of the ban to public office is itself dependent on the length of imprisonment. So it's a very complex system. So if you are sentenced to 5 years in prison, this leads to a permanent ban. If you're sentenced to from 3 to 5 years, it leads to a temporary ban of 5 years. So what I'm trying to say here is that the legislator has already given some thought in advance into deciding who deserves to be disenfranchised. So the court in that case could then say, okay, the Italian legislator actually did think about, who are the more problematic and more serious criminal offenders. So even if it's just, if disenfranchisement is just tied to 3 years of imprisonment, there is already something in the background of this which explains why this is the case. Obviously, the ban is automatic and the judge cannot decide not to impose it. But I think it's likely that regardless of this, the court thought that the norms are sufficiently specific. Okay, so just a few sentences about what this all means for us and kind of how can we generalize and abstract from the court's judgments, both for the situation in Scotland and in general for our thinking about criminal disenfranchisement. So definitely criminal disenfranchisement of convicted offenders or offenders who are sentenced to at least 1 year of imprisonment would not pass the court's test, and I've explained in the cases. So I think if the Scottish government were to pursue a policy of criminal disenfranchisement of these sentenced, and obviously this is a kind of law, and Luke might correct me if I'm wrong, there is indication this will be questioned within a given period of time, so they might decide to do something else. But definitely this does not, in the way it is postulated now, it does not satisfy the court's requirements. Criminal disenfranchisement for particular kinds of offenses seems to be acceptable as long as these offenses are serious. And obviously the seriousness can seemingly be inferred from either the nature. So in the case of scopola, this could be both serious interpersonal crimes and crimes against the state or judicial system, or it could be also inferred from the sanction that was imposed. And in scopola, I said it was 3 years of imprisonment. Judicial intervention does not seem to be absolutely necessary, and this was a question that was discussed a lot. So whether we need a judge actually to decide. And from scopola, we can actually infer that the judicial intervention in deciding whether criminal disenfranchisement is justified in a given case, it doesn't seem to be necessary. So you can take various principles such as proportionality, circumstances of the crime, the relationship between the crime and punishment in advance. So the legislators can already take all of these things into account and then stipulate legal provisions which would take these important aims into account. And finally, I think in more general terms, the court does think of criminal disenfranchisement as punishment, and demands that the countries respect fundamental principles of criminal law and punishment when they devise their policies. And they consider criminal disenfranchisement to be a very harsh sanction because of its symbolic nature. And then for that reason, I think they propose that it should not be imposed for trivial offenses. One final thing for me, and I think this is kind of the gist of the problem, is to actually start to think about what is criminal disenfranchisement really, even though the court says it is criminal punishment. I think we need to give a more serious thought to a question, and Luke makes a reference to this in his article. What is it that we do when we impose criminal disenfranchisement? What is the message that we want to send? And I think one of the biggest arguments against criminal disenfranchisement, I found Luke's example really good here. One has perpetrated a crime, and to his or her crime, we react with a number of different sanctions. And Luke says this nicely. It's like when in a soccer game, it's like imposing both a penalty kick and sending the player off, giving them a red card. Why? Why do we need this double-tracked system of reactions? What is it that we achieve? And in my opinion, what we try to do through criminal disenfranchisement is something entirely different from what we try to do through regular criminal punishment. So that for me is kind of the biggest question, possibly where I would open this discussion for. Thank you so much for listening.
Thank you very much, both, for such an enlightening and interesting discussion. I have a question. Can I ask a question first? Am I allowed? One question is, I wonder why we have to put length of sentence, why the courts, not we, have to put length of sentence as a test of whether there should be disenfranchisement or not. I mean, seems to me that a method where it's by sentence, or certain sentences could attract that particular penalty, but it's perhaps imposed by way of judicial intervention would be more appropriate than having this sentence length, which, you could have situations where, in lots of situations where sentence lengths wouldn't seem appropriate to also disenfranchise certain individuals. But that's more a comment than a...
I think it was a proper question, actually. I think it goes just back to what the last point I said, and that's like, what is it that we're trying to do? If it's, if it's symbolic, and if it's something, if we want to convey to criminal offenders, you don't belong for as long as you are a criminal offender, then there is an explanation of why it may be attached to the sentence. And we might say, well, those who have perpetrated more serious offenses, then they may deserve to be disenfranchised. But then you can make the same argument for saying, well, it should be attached to very particular crimes, because these crimes indicate that you're a particularly bad citizen. So, if you've acted against your community, if you've perpetrated, I don't know, atrocity crimes or terrorism or something like that, maybe there's a more identifiable reason. Just one, I'll shut up in a second. I've actually discussed various regimes that exist in Europe in a very dated article now. it's a 2016 article that I published for Harvard Journal, where I go through different countries in Europe and explain the different systems. And
I'm just looking at the chat. I think Lewis Williams made an interesting point. Does he want to, is he available to speak and raise his, oh, great. Thanks.
Hello, really interesting discussion. I think my question mainly about the duration over the type of punishment was kind of answered after I kind of posed that. But no, I think it was really interesting, and I actually read the same thing which Luke said about Norway and Portugal, how it's based specifically on crimes relating to crimes which may kind of hurt the state compared to maybe hurt the society. In that effect, that would impact someone running for office. So I thought it was really interesting as well.
If I can just make a very kind of brief comment, and there is some level of, you know, when you start thinking about what this is, and I've kind of tried to examine the extent to which policies of particular countries correlate with the wider traits of their penal system. So if you look at like comparative criminal justice and how different countries fare, and yes, again, you will find a lot of, let's say, moderation in the north of Europe, and then you will, you know, find countries such as the UK who in general seem more hostile to criminal offenders. And it's also a matter of historical circumstances. So you will see a lot of countries in Eastern Europe that were obviously under communism for such a long period of time, and where this idea of equal suffrage and, you know, universal suffrage was very strong. And as a repercussion of that, you have still countries that are very open towards including criminal offenders. So there's a lot of going on here in terms of understanding why countries have different policies and what determines them. And it's a very interesting thing too. And I think for some cases, it's just a matter of historical contingency and countries just kind of inheriting policies from previous times and never really considering them. And I think that was one point that was made in Hearst, is that the UK has just had this for such a long time, and it was never actually put for a democratic debate as to whether we need it and what does it do in modern society.
Thank you, Milena. Do we have any other questions? Anyone raising their hands? Don't be shy.
I mean, I have a question, but I've been trying to figure out how to phrase it, because I've been thinking about this from the perspective of, I don't know if it's penal theory or like theories of punishment and versus rehabilitation, and thinking of restorative justice, where the idea is that you need to reintegrate the offender into the community, or at least maintain that link to community. So what impact does all this have not on the individual? Like, how do they interpret something like being denied the right to vote or something like that? So I don't know if there's a question in there. It's just that other perspective that I was thinking of.
I just wanted to say, because you were mentioning this kind of the point of reintegration of prisoners into their communities and the meaning of the lost vote for the communities as well. And obviously, I think Andrea's probably also thinking about the US to some extent, where the consequences of this are unequally distributed within the population. And there's been research actually as to how the denial of the vote impacts the communities, well, the immediate communities of criminal offenders, and how much they become disinterested, not only in voting, but in other forms of political participation. So I think it's a very important point. And all of that kind of, I guess, goes back to these wider theoretical points that Andrea just made, which are about, you know, the idea of punishment as reintegrative as communication, as reintegrative communication. And, you know, the denial of the vote to people who haven't done serious offenses. We might want to talk about more serious offenses. I think there's scope for discussion there. But just to do it automatically and blanketly and you know, include everyone who's done very minor crimes, it doesn't make any obvious sense whatsoever. Only when you have it, you think of it, oh, we have it, and you know, so it's there. But if you don't have it, if you come from a country that doesn't have it, this was probably kind of mine. I came from a country that didn't have it, to the UK, and I thought, like, why would you be doing that? But then you start to think about the wider traits of the penal system and everything.
Yeah, a fascinating discussion, and thanks for the presentations. I came to this question via a broader interest in rehabilitation and desistance from crime, and in a sense, it was studying that literature that drove me to explore questions of citizenship and political participation. But one specific issue that arose for me in sort of thinking through the implication of disenfranchisement for rehabilitation is, this is trying to summarize an awful lot of ideas and research really simply, so bear with me. But basically, I think if attempts to work with people to support their rehabilitation, if they are to have legitimacy, and incidentally, if they're to be effective, there's lots of evidence to suggest that the approach that we take has to be dialogical rather than monological. Right? In other words, you don't lecture somebody into compliance with the law. You engage in a dialogue which may be persuasive. And I think the problem, so when I think about that in the context of being disenfranchised, you can't have a dialogue with somebody whose civic position is silent, right? So disenfranchisement silences somebody politically and says that their voice doesn't matter and shouldn't be counted. And therefore, I think so long as you disenfranchise prisoners, you undermine the possibility of conducting rehabilitative activity in a way which is legitimate and ethically acceptable. And there are all sorts of consequences of that, you know, alienation, delegitimation, post-release, the relationship between what I think in the blog that Javier and I wrote a while ago, we talk about the difference between substantive and formal disenfranchisement. So people that get locked up are already substantively disenfranchised in lots of ways. We formalize that position and make it worse, all of which pushes away from constructive engagement with the state and any possibility of dialogue. So it was interesting. I gave evidence on these questions to the Equalities Committee right at the beginning of this process, and I was really struck by how the parliamentarians, at least on the committee, approached the issue with an assumption under a basic social contract logic that people should be disenfranchised. But within half an hour of conversation on the subject, their minds were changing as they kind of thought through the implications of their own positions. That doesn't mean that politically it suddenly became simple. But I think there's so much to be achieved by surfacing these arguments in the public sphere and engaging people with them seriously, because the usual arguments for disenfranchisement collapse pretty quickly under any serious scrutiny. At least that's my view, but I'll shut up. Sorry, that was more of a rant than a question. But
I think that's completely right. And I think, you know, we don't make sufficient distinction between the various categories of criminal offenders. That's also, you know, once you start talking about the reality of crime and, you know, the reality of how most offenses actually lack this element of seriousness that people think, then people are, I think it's much easier to persuade them in that way. But I think one point that's often been made against, so in general, it's always considered that giving them the franchise is positive in the sense of their rehabilitation or the prospect for rehabilitation. But there's also a counter argument that kind of taking away the franchise teaches them a kind of a civic lesson, a lesson of what it means to be a citizen, and then they will learn from that which I never found very persuasive. It's not like they will desist from reoffending just because they will lose the franchise. But I think the bigger question that, I mean, you're asking here is the question that bothers me the most. We have to decide whether these people are still citizens. And if they're still citizens, then we have to make really, really good arguments for denying them elements of their citizenship, especially the elements of political citizenship. So I don't, you know, for me, this is kind of the crucial question. If you resolve that, then everything else gets dealt with easily. But again, that may be too simplistic.
We've got a question from Ramal. Ramal.
Hi, yeah, thank you for that. I was just going to say about it's difficult in terms of the voters' rights because of the public outcry. So how would you, persuade the public? I mean, that's a big conversation in itself. And then just thinking about the role of the private state and particularly the prison, for instance, how underfunded they are. I know particular organizations own a large proportion of the kind of the structures and the systems are in place.
Maybe I can just very quick, very brief answer to the first, at least the first bit of the question. There was research done in the US where it was considered that the population is very much against giving prisoners the franchise. But, once you start nuancing your question a little bit, once you start kind of explaining that, people do very different offenses. And when you start asking, okay, would you consider that that criminal disenfranchisement is justified in the case of, bicycle thieves, they would say, doesn't make sense, right? So once you start kind of going through that and explaining, and I think the intuition of the public, I hate when people ignore, public opinion. I don't think it makes sense. But when you start asking the right questions, you then actually see that people are not that much against. So much like the point, Fergus's point before, the public is not that hostile if you can just ask the right questions.
Well, thank you so much. It's been such an interesting conversation. We're posting details of our next event, which is on the 8th of December on Zoom. Please register. We've got Dr. Laura Janes, the legal director of the Howard League for Penal Reform, talking about prisoners and COVID in England and Wales. Thanks again to our speakers for taking the time to share their knowledge and insight into this issue. It's so important. And I wish you all the best. And please keep following us and attend our future events. Thank you.
Thanks so much.
Cheers. Bye.
Thank you, everyone.